commercially exploit it. But it is subjected to the national laws and international agreements in regard to the intellectual creativity. So if you are an inventor and you create something good, useful to the public, then the government will give you a right. That is called the intellectual property right. And this is an exclusive right. It's a right given only to you. What will you do with that right? You have to exploit it commercially. You should make money out of it. Okay? And this right which you get can be assigned. You can sell it to somebody, you can license it and make money out of it for financial benefits. So intellectual property is a collection of rights. There are lots of rights. It's not just one kind. There are something called registered rights and there are something called unregistered rights. IP rights usually is registered. When you register, you have protection. If somebody tries to take it away from you or without getting your permission tries to steal it, you can always go to court. That is the major reason why you have to register the rights. But there are some rights which are unregistered too. So we are going to study each one in detail. The registered rights are patents, formulation. Nobody other than the most important people in the company, say a handful of people, know the actual concentration and components involved, the secret ingredients which is used in Coca-Cola or KFC chicken masala or Maggi masala. Nobody knows that. That is called confidential information. And now that is there only with the bare handful of people of that company. And it's not something which they are disclosing to the public. And this is something which the company holds as confidential information. And that is not disclosed to anybody. Now that is the reason the company can make a lot of money and protect it. But the thing is, the risk value is very high there because it is not protected by means of an agreement or something like that or registered. So based on the goodwill and agreements between the people who know it, the confidential information is held by the company. But the other rights here, they are all registered rights. Okay, so let's go to the next. Intellectual property involves a lot of things, like say for example patents. We'll do each one in detail. Patents, design, patents, trademarks, geographical indication, copyright, designs, trade secrets. Confidential information and trade secrets are almost the same. And layout, design of integrated circuits and plant variety. So let's see what is patents. Patents are granted for inventions which are having technical nature. Say for example, you have invented a drug. The formulation of the drug is what you get patent. Say for example, you have invented a plant, the genetic mutation, and you have invented a plant. Now, normally, let's forget about the plant. Plant is not given patent in India. Say, for example, you have made a ointment for say pimple or for making whitening the skin. That's much more in the market now. So if you make such kind of a composition, now that is a new composition and that can be patented. Say for example, you have made a new mobile, the technology of the mobile, that will give you the patent. Patent state. Patent rights are territorial. If you file a patent in India, it is only applicable in India, not in US. If you file similarly in US, it is only valid in US. So actually patents, intellectual property, countries make money out of it. Okay. So you cannot file a patent in one country and expect that you are protected in many countries. So you will have to file it in the way if the if a country is it's not going to be useful there, then there's no point filing a patent application in that country. So patent rights are territorial and they give you protection for only a limited period of time. You get protection when you apply for a patent for 20 years. How many years? 20 years. But if you see confidential information, which we just talked a little before, there you can have never-ending protection if you can protect your confidential information. But the same is not true with patents. With patents, you will get protection even if you disclose it for 20 years. In 20 years, you can make money out of your invention. You can sell. You can do everything you want. Patents are for inventions. It can be a product, say for example, a composition, a drug. Okay, it can be a process. If you say, for example, you made a biscuit, and the process you make the biscuit, and the apparatus which is used for making that biscuit, you will get all three products. It can be either a product, it can be a process, or an apparatus. But it has to be novel. Novel means it has to be new. It should not be known before. It should be something totally new. And in return for your patent application, in return, you will disclose completely what are ointment for whitening the skin. You will have to completely disclose. At least 90% of the details should be there, because after 20 years, anyone should be able to make it. Not anyone, a person skilled in art, a person who is in that technology should be able to reproduce it. He need not come back to you and say, I have to pay money to get the knowledge. He does not need to come to you. So that much of disclosure must be there. So here you give disclosure. The terms are state specific. Every country can have some rules that are a little different. Like say for example, US grants patents for animals and plants, whereas India, we do not give patents for plants and animals. So the terms can be a little different from state to state. Some may give much more, they may be more liberal, some may be more stringent. They are more, they allow patents for everything. But if you see the developing and the developed, underdeveloped countries, we are a little more stringent. Okay, the protection is very broad and it is defined by the claims. It depends what you write in your claims. If you claim, say for example, you made a invention is a pen refill. Okay, a pen. You can write it as a writing instrument wherein wherein the writing ability is due to a liquid which is flowing from a nib of a in which there is a canister, in which there is ink, through which, and when you start touching it on the paper, ink flows. Okay, so that is how you can describe it. You can also say a pen as a writing instrument. Now a writing instrument, if you write it as a writing instrument for a pen, you could also say it is a feather which you can dip in, you can dip ink and write. Even that is a writing instrument. Even a stick, you can use it for writing. Even that is a writing instrument. So your claims have to be properly defining what you are trying to claim. If you have actually invented a pen, which is a refill-based pen, you have to write it. Your claim must actually define your pen, not give a vague description of a writing instrument, which can be even a needle dipped in ink, to something very sophisticated. So, the claims define the protection. If you define properly, you will get protection. If you are very vague, then your protection is also negligible. Patents are expensive and they are time consuming. It takes a little time and it is difficult to obtain because you need to actually satisfy a lot of requirements, but it's not very difficult and it is expensive to enforce. Is this okay? You can just show me a hand. That way I will know you got it. The people who are viewing. Is that yes? Okay. Then next. Let's go to the next one. That's designs. We're talking about registered designs. Now, design is for anything which is appealing to the eye. So, you can get designs. Intellectual property has not only one part. I told you it's a tools. You have so many things. The second thing is the designs, which you have to register. Designs are for any article. It is the shape, the aesthetic, imaging. Okay. For this also, it has to be new. The design feature must be new. And the moment you get it, you can, by chance, you market it before you apply. You have 1 year timeline. And once you get a register of design, you can put it on the article itself that it is registered. So it is R with the round on it. You can protect computer graphical images, drawings also with the designs. Industrial and handicraft items are also given design protection. But the important thing about design is it has to be new and it has to have an individual character. The rights here is for 5 years. You get protection for 5 years, and every 5 years you will have to renew it for maximum of 25 years. With respect to patents, it's only 20 years. There is no renewable chance. But for designs, you have 5 plus going on to 25 years. But designs are not very design right when you see it. Like say for example a sari. The sari, as soon as you see it, you feel it's beautiful, right? Or say for example the water bottles which are on your table. Okay. That gives you a design, the shape of the bottle. But you have, I think, 3 ridges on your bottles. If you have a little different design on the same shape of the bottle, you will another design. So design, you have to, when you apply, you have to think in a little broader sense and see how people can modify it and file many design applications. Okay, it is very easy to get designs, but not so easy with respect to patents. Patents have to be, we will be discussing patents a little while later also, so we'll do that. The next is trademarks. This is again designs. Designs, it depends on the category of articles. You can have different designs. So when the design application comes, we'll ask it which class it belongs to. So if you are doing it for a measuring instrument or a furnishing like sofa, table, chair, it goes in that particular category. If you're going for household articles, we have a different classification system and we search it based on that. Research if similar designs are already there in the market for that particular goods, and then we give you a report. The third is trademarks. Trademark is for any name, word, logo, symbol, or device which you usually associate with a product. Say, for example, the Prestige cooker. I think everybody has one Prestige cooker in your house. So you may have the very old model Prestige cooker and you may have the most latest iodized one. If you have a range at home, if you go home, just notice how much of a difference in design you have. And if you come to the most iodized one, you have beautiful shapes. Now that particular shape is also protected by means of design. And that name, trademark name, Prestige, is called the trademark. Okay, it can be just the design. If you just see the name, you can sometimes see the name, sometimes you can see just the mark and say that it is Prestige. So that is called a trademark. Trademark does not have a timeline. It is protected indefinitely. And trademark, like say for example, I'll give you another example. If you want to buy a cooker for your house, you would first think about Prestige. So why did that thought come? Maybe you are 18 years old, maybe you are 60 years old, you would still associate a brand name saying that that brand is better if it is coming within your budget. Say, for example, a mobile. If you have no limit on your wallet, I think you would go to the best phone, that is iPhone. Why would you want to go for an iPhone and not go for something a little more lesser? Say, for example, Samsung or Nokia. It's because of the brand name. The brand name, say for example, iPhone, Prestige, Samsung, these are called brand names. You associate each brand with its brand name because of its quality. You know that it is the best. Why did that feeling come into your mind? That is because of the brand. So brand names are very, very expensive business. People sell brand names, and that's how it goes. So trademarks involve the brand names. Okay, it can be just marks, it can be a symbol, it can be the name. Okay, so I have given you some examples, but the trademark has to be distinctive and not descriptive. You cannot have, say for example, you are having a product which is an apple juice, you can't call it apple. The name and the product should not match. Okay, it must be distinctive. Say for example, Apple laptops. The name Apple is not describing the product. You cannot associate the name Apple with the Apple actually. So it should not be describing the article. It should be very distinctive. So that is one of the most important things about trademarks. Distinctive and not descriptive. You can acquire trademarks by use. You're using it for so many days and you can register it later. Or you can first register it and then use it. The protection can be variable. When you apply for trademarks, you can say that you want to use it only for one particular category of tools. Or you can apply it for many category of tools. So there are some trademarks which are used only for one product. And there are some trademarks which are used for many products. Say for example, Titan. Titan is used for watches. You can associate Titan with just watch. But if you take the name of Apple, you can have tabs, you can have mobiles, okay, you can have computers. So many things come. Okay, or for example, Tata. You have grocery like Tata Salt and Tata Shakkar and all that, and you also have Tata Nano. Okay, so it is the same brand, the same trademark used for across multiple classes of products. And the cost is not expensive. It's much cheaper compared to patents and designs and all that. And the protection is very lengthy. You keep paying the fees and you can renew it as long as you want. Okay, this much is fine. Are you guys getting what I'm trying to say? Okay. So trademarks you can apply before using it. You can apply in the office.
Yes, ma'am.
Okay, that you want to use. Thank you. You can apply it before you use. Okay, you can register it before you use, or you can use it and then apply also. What is the advantage of registering before you apply? If somebody sees that your product is going very well, your name is very important, and people are believing that it's a good product, they can always copy it and use it. If you have registered, you can always go across legal ways. You can stop them using your brand name, okay, without your permission, legally. You can go across legally because you have registered, you have a document. By chance you have not registered, the case becomes very difficult to prove that you were the owner of it and that the other person has actually cheated and he is using yours. That is why registration is very important. And the moment you register it, you put this mark R. Okay. Copying is not necessary here. I'll show you one or two examples for that. It's easy to obtain. Only thing, it has to be distinctive. So I have some examples for you to see. But it is very expensive to enforce and litigation is very costly. So once somebody copies you, okay, then it becomes very difficult to stop the other person. You need to have lawyers who will go to the court and, but if your brand name is so good, people go at any lengths to save it, and stop others from using it wrongly. I have some disputes which people have filed. If you see the name, it's very, very similar. It's not exactly copied, but it is similar. Okay? If you are buying something very quickly and going out of the shop, if you don't really see the name, people actually try to cheat. Okay? The cost will be a little less than the actual product, but the name is very similar. The color, the shape, the box, everything is same. Just the name, there is a little difference. Okay? In trademarks also comes service marks. Service marks they are used for a service. It's used by a service provider. Like say for example, your college will have a brand. Your college name may have some symbol. Similarly, we have like CSR or Indian Army or Indian Navy or Indian Railways, Postal. These are all service providers. Okay? Or say for example, the transport buses, that they have a specific logo. Now these logos are related to a service and they are not called trade names, they are called service names. Okay. Now this is actually just an overall idea of what is patent, design and trademark. So I have given you an example of a cooker. The technology of this cooker, the constructional feature of this cooker will be given patents. Okay. So if you have a new cooker which is using very little oil and you can cook it and it's much faster because of an advanced, they have added a new feature in this nozzle. Okay, so that way you will get a patent for it. The design is just the shape of this cooker. Is it looking beautiful? Is it looking nice? Is it helping you cook? Can you just hold it easily? These kind of features. Okay, most important is whether it is aesthetic. Is it looking really nice? Aesthetic design. Okay, trademark will be the name on it, say Prestige, Hawkins or whatever. Okay, next coming to copyright. Copyright is something which is given to expression of an idea. This has a very narrow protection. Copyright protects pictures, movies, paintings, photographs, but it is the expression and not the idea itself. Say for example, Leonardo da Vinci's Mona Lisa. Mona Lisa is a portrait of a woman, right? So the portrait of a woman sitting or standing. If somebody draws a picture of another woman sitting or standing, it will not actually hinder copyright. It is if you just copy exactly the same picture, in the same stroke, in the same facial pattern, only then it is infringible. So copyright is not just the idea. It's not like patents. It is not, if you just draw the face of another woman, it will not hinder it. It is if you just copy exactly Mona Lisa, only then copyright is infringible. So if there is a modification, if you're doing somebody else, or say for example a beach picture, you have so many great artists drawing a beach picture. If you try to copy exactly the same, then only it is infringible. Okay? So all the characteristics, all the features, all the words, if it is the same, if the music, the lyric, the movie is exactly the same, only then copyright is infringed. Say for example, Harry Potter. If you try to copy, instead of Harry, if you make it Larry and you make a storybook, okay, with the same kind of a storyline, only then it is infringible. But if you will modify it, there are so many magic children books now available after Harry Potter. So copyright is having a very, very narrow protection. And the moment you register it, you can use this C symbol. Okay? It can be for 2-dimension or 3-dimension things, like statues, even that are protected by copyright. The moment you create it, copyright starts. Okay? You can register it. If you register it, you can put the C mark. It is not expensive. The length is very long. After the death of the author, 50 years, you will have protection. So a lot of Vairamuthu's lyrics, A.R. Rahman's songs, they have a very long time of protection. That is why copyright is a very, very important thing, and these artists earn their royalty because of this. And the moment you create it, you get protection. But you have to register it. It is easy to obtain, but expensive to enforce. Geographical indications is another one. Till now, what we spoke about is something which a person will usually create. Okay, it's an individual or 2-3 people combined inventions which we were discussing. Geographical indications come to a very totally different class of products. These are usually made by cooperatives. Say, for example, there is a country or a place where people are doing the same art. So all of them combine and apply for geographical indications. So geographical indications identify goods which originate from a particular place. Say, for example, Kanchivaram sari. So in Kanchivaram, there are so many weavers who are actually making this sari. So they form an association, a cooperative. They all abide by the rules of making a sari with how much amount of silk and how much amount of color, which colors and which designs. And they will agree to have a similar format and apply for a cooperative and apply for a GI. Okay, so the GI is granted to the cooperative only, not to a single individual. So it is a group effort. So best examples is Kanchivaram silk, champagne, Darjeeling tea. Okay, you have a lot of them in India. Customers should not be misled. Okay, that is the major reason, because you have, if you say Kanchipuram sarees, there are so many Kanchipuram sarees. But now you usually search for the silk mark. If the silk mark is there, that is original saree. And the silk mark only will come with the cooperative, not without the cooperative. So it will help people who are buying it that they are not cheated and not being given a lower product. And other side, the artists who are actually doing this, they will be benefited by being paid properly. Okay. So there is economic prosperity, and the marking will help you buy the correct product. So similarly, around the world, if you see, there are so many products which are geographically linked to that particular places. Okay. Like for example, the Swiss cheese, okay, Roquefort cheese, the chocolate, Swiss chocolates, champagne, okay. Coming to the next aspect, that is plant variety protection. India, we don't give patents for plants or animals, but for plant varieties, a new plant variety which you have bred and you made it, we do give protection under the Plant Variety Act. So breeders and farmers get right. So it is the only right where both the breeder and the farmer gets. But for that, you need to have, it should be a new variety, totally new variety. It should be distinct, uniform and stable. Okay, so you have to show that your variety which you have made is stable across at least 6 generations. Otherwise, it shouldn't lose its character. So you have to show them that. So this is the PVP Act. This much is fine. Yes. Is it? Now we go into patents. So patents are exclusive privileges. See, patents are a little more important. It's more difficult, and that is why I am emphasizing on patents. Patents are exclusive rights which are given by whom? By the government. Given to whom? To the inventor. Inventor is called the patentee. For a long time. How long? 20 years. Why? For commercial gain. See, as academics, I think you people must be writing a lot of paper publications when you invent something or when you get a new finding. With the paper, you get a lot of fame, okay, you get the name, but you don't get any money. So patents give you money. They give you fame, name and money. So if you cannot exploit it commercially, there's no point going to patents because you have to spend also. When you spend, you are supposed to make money. That's why people are filing patents. So if there is no commercial gain, if you're not going to commercially exploit it, then it's better not to file a patent. Go for a paper publication. So government is giving you this and you are paying for so many things for commercial gain. In consideration for this exclusive privilege, you have to give a full disclosure of the invention so that after 20 years, people can use it without your permission. So once you get a patent, what can you do? You can stop anybody from making it, using it, selling it or importing your product or the process into your country. For how long? For 20 years. Provided you pay maintenance fee. Okay. Once you get a patent grant, you have to pay a minimum amount of money to the patent office for maintenance. The moment you don't pay, you may lose the protection. And if somebody infringes, you will not have a stay in the court. They will first say if you are paying the fees. If you have not paid the fees, then they'll say your patent is invalid because you have not maintained it. Okay. So it is very important that you have to pay the fees. So patentability requirements, every country has its own law and it is territorial. Patent rights are territorial. You cannot say that in US plants are given, animals are given patent, so you give it in India. Every country has its own law. So it's not a uniformity. So if you file in a particular country, you will only get patent in that particular country. So, but if you have a plan that you want to file in many countries, you can file one application. It's called the PCT. And with that application, you can give a request to the countries you are interested and pay their fees, and the same application goes into all of those countries. The next thing is first to invent and the first to file. You can be the first to invent, but the person who files it first in the patent office, he's the one who will get the patent rights. You may have invented it, but it will take a very long time in the court to prove that it was your invention. But if you first file it, you can always prove your case. Okay. So for patents, it is more important that you be the first to file. So what are the requirements for filing a patent? It has to be novel or it has to be new. It should be inventive. Nobody should have thought about it. Third, it must have an application. Without an application, nobody will buy it. The last thing, there must be disclosure. Like how I told you about the pen. If you are inventing a particular thing, stick just to it. Don't go too broad. If your claims are not clear and it's not going to disclose what you've done, you will not get protection. You cannot argue in court. So what is a patent? It is the inventor or the assignee is providing a techno-legal document to the government. For 20 years, you get protection. For that, it has to be novel, it has to be inventive, it must have an application. Then you can make money. Okay? Okay. What is novelty? Something that is not known. You should not be knowing that. It should not be in the disclosures. It cannot be in, say for example, an Ayurvedic solution, hair oil. It should not be known. It shouldn't be something your grandmother was saying you file a patent for it. That is called traditional knowledge. So it should not be known. When we search, we see all documents, whether it's on the internet or documents which are published or something which is there in the palm leaves. Okay, all that is now made into internet, into the database. All those data is also entered into the databases. So we can actually search all kinds of publications. So you cannot say that it was actually a pamphlet or it was just a seminar. But if it is presented and published, yes, we will catch it. Second thing is it should be reproducible, and third thing is it should be inventive. Okay. Now, what is an invention? It can be a process or a method of manufacture. You can otherwise make a machine apparatus or any other activity. It can be a substance produced by manufacture, or it can be anything useful or an improvement. Okay. Let's see, for example, this is the computers of 1946. In 1964, it was a little more different, and in 81, it was a little more bulky. 99 is this. Now, I think in 2020, we have watches. Okay, so that is how technology is improvising. So it can be any kind of technology. So you can have a single invention, say for example, just one, say for example, a pen, or just a biscuit composition, or just say a pimple composition, or just say a mobile. Or it can be the method of making the biscuit, and the whole apparatus for making it. So you can have the product, the process, and the use. Say for example, a drug. You made a COVID, okay, the COVID vaccine. So it can be the COVID vaccine, the method you made the COVID vaccine, and the use of the COVID vaccine. Or it can be just the process and the apparatus. Or it can be the product, the process, and the apparatus used. Okay. So what is the objective of the patent? Why should you file a patent? To encourage inventors. Okay. To encourage inventors to provide protection for disclosing their invention. If you encourage inventors only, you will be getting a product like this from a product like this. If you don't encourage inventors, what happens? We will be still sticking to 1946 computers. Nobody will improvise. Now everybody knows that you will get a lot of benefit financially if you invent something more modern, more better product. So we have such a drastic change in inventions. Okay. And in view of it, in view of disclosing the invention, you will get financial benefit. So it benefits both the public and the inventors. And the working of the patented invention on a commercial scale within reasonable and practicable time is very, very important. Once you get a patent, if you just hide it, lock and key and keep it, it will not help. You are supposed to work it out on a commercial scale and provide it to the public within a reasonable and practicable time. By chance you don't do that, others can say for example, the COVID vaccine. Assume we have got a patent in India. And after that, if the company is actually importing and not having enough supply of the vaccine here, then a third-party company can always come in India and say that, see what they are manufacturing, they are bringing it from out. Okay, they are importing it. And so the amount is very less. And it's not enough for our people. So we can manufacture. Then the government has the power to ask this new company to produce it in India in a reasonable amount, okay, in a reasonable cost, okay, in a practicable amount of time. So that is why. What are the advantages of a patent? It will avoid duplication of research. It will help you give the latest technology. Even the industry can improve the technology and you will get cheaper products and better products. And it is also an indicator of achievements for industry, R&D and researchers. And you can also record the information for future references. Now we are going to a next, a totally different topic. So do you have any questions in this much? Okay, let's go to the next one. So we are going to the non-patentable subject matter in India. The first thing is section 3B. Okay. In section 3B, anything which is any invention wherein the commercial exploitation is contrary to public order or morality is not patentable. Like the process for cloning human beings, modifying the germline identity of animals or humans, or using for the industrial or commercial use human embryos. That is not a patentable subject matter. Say for example, you are making an animal, okay, which can be used for cancer treatment, okay, wherein it is very, very sensitive to get cancer. Now those kind of modifications actually give harm to the animal, okay. So those kind of modification of human being or animal is not allowed under section 3B, like cloning human beings, where they are, very powerful or better, for making mass, for for the military purpose or something. Those kind of things are not allowed. Okay, that is against morality. So anything which can cause prejudice to health, human, animal, plant life, or environment is not allowed. Say for example, you're making a bomb. Those kind of things are not allowed in India under section 3B. Or you are destroying plants and animals, or adulteration of food devices which will help you, adulter. Those things are not allowed. Under section 3C, a mere discovery is not allowed. It can be a living thing or a non-living thing. Say for example, you're getting some soil, okay, or a bacteria you isolated from soil, or a mineral you isolated from soil. If you state so, it is not allowed because it is just isolation. You have discovered it. It's not an invention. Okay, it's a discovery. So if you find a new form of something known, that is again not allowed. Say for example, you are using ginger. If you make it a liquid ginger so that you can use it for cooking, it is not allowed. Say for example, you are using aspirin for headache. Now you can use it for cardiovascular disease. It's a new use for a known drug. That is not allowed. Okay, that way you can have evergreening. So to prevent evergreening, section 3D has come up. Section 3, this is for mere admixtures. A substance which is obtained by mere admixture of aggregation of properties of components. Okay, so say for example, I think a lot of people have hair fall problems. So you know that aloe vera say that it is helpful, it will not give you a patent. Okay, you have to show that individually they are not giving you this activity. In combination, they are giving you this activity. So there must be some extra effect when you combine them. That is called synergy. So if you can show the synergy data, you can get a patent. But if you say Brahmi, Chikakai, aloe vera, all three of them are showing you an activity of say 10 each. And when you combine, you're having an activity of 30. That is an additive activity. It is not a synergistic activity. If each one is giving you 10 and combined you're giving activity of 70, then that is an added activity. That is an extremely a big jump. So that kind of activity is called synergic activity. Okay? Method of agriculture and horticulture is not allowed. So agricultural methods are like crossing, preparing an improved soil, weeding, using weedicide, or spraying some chemicals so that the insects are not coming, or improving the soil using earthworm. All these are general agricultural techniques which we have been using from ages. But there are some applications which come from abroad under section 3H. Okay, prophylactic methodologies: medicinal, surgical, curative, prophylactic, diagnostic, therapeutic techniques for treating humans or animals to increase their economic value of the animal or the product is not allowed. Okay, so removal of cancer or transfer of tumors or blood transfusion, vaccination methodologies, surgical methodologies, diagnostics are not allowed. Coming to section 3J, plants, animals in whole or part is not allowed. It can be seed, it can be a cell, it can be a leaf, it can be a flower. It's not allowed. Essential biological methods of production and propagation of plants and animals is also not allowed. So the normal growth of plants from allowed patent. Section 3K is like mathematical methods, business methods, algorithms, computer programs per se. They are also not allowed. 3N is for presentation of information. When you normally buy medicines, some medicines or hair oils and all, you get this pamphlet. This is actually a kit, and that paper pamphlet is the instructions to use. So that actually gets covered under copyright, and that is not patentable. So presentation of information you cannot get a patent for. Then there are other categories which we do not allow, like frivolous inventions, inventions which are contrary to well-established natural laws. You can even have arrangement and rearrangement of known devices. Say, for example, a torch with a stick so that you can beat. If you're going out, you want to beat, so you just pull and beat. So something like arranging and rearranging, that's obvious, okay? So that is not given patents. You need to have something totally new. A literary, dramatic, musical, or artistic work or an aesthetic creation is not given patent. You get, what do you get for this? You can get copyright for that. A mere scheme, rule, or mental act or a method of playing game. A mere scheme or a rule, you will get again copyright. You don't get patents for that. The topography of integrated circuits, you have a integrated circuit act and a law, you have to get it from them. You don't get patents for this. The next important category, section 4, which is non-patentable inventions. Anything which is related to radioactive material, okay, fusion or fission material, the radioactive reactors, they are not given patents. We send these applications to the DRDO, Defense, okay. Now, to the DAE, the Department of Atomic Energy. The DAE will decide if it can be patented or not. If they say no, this is related to DAE, then it is not patentable. And once we classify it under section 4 and send it to DAE, until you get clearance from DAE, these applications are not dealt with. They are kept under secrecy. So compounds relating to uranium, radium, plutonium, lithium, or any fission, atomic energy related inventions are not coming into our purview until we get clearance from Department of Atomic Energy. And just before I go to the next, there is also another group, inventions which relate to warfare, biological warfare, or just warfare. Like say, for example, a piston, okay, some chemical compound which can be used as a nerve gas to cause diseases, influenza, or mass bomb, biological warfare, like some release of some strain bacteria which can be used to infect, say like example like COVID. These kind of things we send it to DRDO, and until you get clearance from DRDO, these applications are held at bay and patents are not granted for them. If you feel that it is important for the defense of the country, those inventions are all out. It goes to DRDO. So, say for example, you are the inventor and you have invented. What should you do and what should you not do? Before you file a patent, don't publish it anywhere. By chance you have published, within 1 year you have to file a patent application. So you can file a provisional application. A provisional means just an outline, okay? Just an outline. You can just give us an outline and you get time for 1 year, after which you can file the complete specification. Okay, in this 1 year time, you can check the technical or the commercial viability. Can you sell it to somebody, or can you itself become the innovator and start selling it? You can check if the market is feasible. Okay, you can do a lot of viability testing, and if you feel yes, then you can go and file a complete specification. And after the complete specification, you can file a request for examination, and then you can get a patent granted. Okay, once you get a patent, you have to commercialize it. You have to make it, sell it, license it, assign it. You cannot keep it under lock and key. You have to exploit it because you have to pay fee. And this whole protocol, till now what we discussed, that all has fee at every step. So you have to commercialize when you get a patent. And after you get it, you cannot just keep quiet. You have to do field work. You have to see who is using your own invention without your permission. If somebody is doing it, you can sue them. Okay. So do you have any questions? Any? Yes, copyright registration. Copyright registration, ma'am, it is in our website. It is in the Ministry of HRD. Copyright comes under the Ministry of HRD. The whole protocol, there is a manual for you have to maybe read the manual once before you register it. You can do it online. It comes under the Ministry of HRD. You have to, I think, submit it online and you have to fill up all your forms there. It's very simple. It is there on the website. Then you can have the whole protocol there. And you can submit it online. The forms are also downloadable, so you can download, fill it up, and upload it. The manual also has the fees, the forms, and the documents you have to file. Patent rights. What is the minimum and maximum cost of the patent rights? The cost depends upon the minimum fee which is there is for 30 pages and 10 claims. The fees will depend upon whether you are an individual, whether you are a company, whether you are a small entity. So depending on that, the fees will change. So I actually had another presentation, but then your time is very, very limited. So I advise you to, so for 10 claims, okay, 10 claims, one priority document and 30 pages of specification, the fees is calculated. So if you can visit our website, you can see whether you are an individual. See, individual means you as a single person are filing. Say your college is filing, the fees is 4 times more. If you are a small and medium enterprise, then the fees is different. So you will have to see the fees. And depending on the number of claims, for 10 claims and 30 pages, we have a fees. Okay? But it depends on which category. So I don't know which category you are asking me about. Okay? If you visit our website, it's called ipindia.gov.in. You will get the whole, the manual of patent practice. So you will have the whole fees. And if you do online filing, you have 10% reduction in fees. Okay? And is there renewal after 20 years? No. There is only maximum 20 years. 20 years is the timeline of the patent. After that, it is not going to be valid. It becomes invalidated. The patent term expires. The term of the patent itself is 20 years. And patents are expensive because minimum patents, it's 30 pages is fine, but for each additional claim, you have to pay 2,500 extra. Yeah, give me a minute. Can you see? Can you see this? So this is how the fee will be different for different individuals. For individuals, for SME, and for company, the fees is very very different. Okay. Yeah. Please ask me what you were asking something. Where should we start? We raise queries at starting for patent rights. Uh, does property like villa need patent rights for commercial purpose? No, property rights doesn't need patent rights. Patent right is a intellectual property rights. Okay. So anything you create, like if we go back to our first slide, I just closed the slide. Okay. Anything which we have created intellectually, it can be okay. It can be. I'll have to open the first slide. Give me a minute. Okay. Anything which we create. Okay. Creative thing which we create. It can be in the industrial, it can be in the scientific, it can be in the literature or artistic field. Only that comes under intellectual property. Villa, land, those are not, those are tangible. What is intangible? That is only coming under intellectual property. There should be raised queries at starting for patent rights. What do you mean by that question? Why should you start queries? You mean to say when you want to file a patent, you should approach somebody. That's what you're asking. Okay. See, if you have made an innovation, you can always contact. There are a lot of organizations. If you see, okay, like you can go to agents, lawyers who are patent registered patent agents, who will help you draft the patent if you have the money, okay. Or if you feel you cannot afford, you can go to government organizations, NGOs, or like NRDs. These are governments, DBT, Department of Electronics, depending on the thing. TIPAC is there, and I think Tamil Nadu government also have IPR cell. So you can always approach people like this. If you have a lot of money, you can go directly to a patent agent. Okay, that will cost you. Patenting is not a cheap business. It's quite expensive. If your invention is really good, you have to maybe directly go and deal with a good patent agent. Or if you say you would like to do it on your own, you have a lot of websites. I actually prepared it so that but then there's not much time because your 1 hour slot is very, very little. So you have different country websites. Say, for example, Indian website is this. You have a lot of countries, but Wi-Fi is the most important one in addition to India. So if you have an invention and you would like to do it on your own, First visit the country, like say for example, India, first visit our website, open it, you will get the manual of patent practice. So go through it, okay? Go through it and see what is the protocols, the procedures, how you can file it, what will be the cost and all that, and what is patentable and first what is not patentable. And after that, if you feel yes, you want to, then you have to search if your invention is really new and inventive, okay? For that, you can visit either WIPO or you can visit European Patent Office, the US Patent Office, and search. Or the best thing is to go for Google Patent. There is like how we use Google Engine. You have a Google Patent Engine. So you can actually search with keywords. You will get lots of inventions. Say, for example, turmeric cream, okay, face cream. So you can put turmeric and tulsi face cream, okay, plus you will put plus plus and then search in um, Google Patent. You will get so many patent documents and non-patent literature. Um, okay, you can search and see how people are drafting the claims, and that's how you have to draft. And if you normally see a paper publication, how you write a paper. So the whole paper publication is almost like a patent document. The only difference is you need to have claims. Now, claim writing is the most important thing because claim is the boundary of your patent application. So, to learn about how to write the claims, I suggest you visit the other, use Google patent and then search similar patents and see how they have drafted it. And you can actually similarly draft it. Another thing is, if you visit our Indian Patent Office website, you will see a list of patent facilitators, patent agents who are doing patent facilitation. Okay, so you don't have to pay them much. Okay, they will help you draft, they will advise you on how you should do it and all that. So depending, I think the email IDs and the phone numbers are already there in the website. You can choose the person you would like to approach and call them and then decide whether your application is really worth it to go about. Okay, whether they can do a search and tell you if it's new or novel and all that, and how best they can draft it. Okay, you can do all those things. The government of India actually, because of very little interest by academics institutions, they have given this opportunity. So you don't have to pay them, and the government actually pays for them. So you could utilize that. It's a very good time if you are interested to file patents. I hope I answered that. List a few benefits that governments provide to patent right membership. I didn't get that question. What benefits are you talking about to patent right membership? There's no membership basically. It's not like all people who have patents are going into a member club. It's not like that. It's not like a club membership. The moment you get your patent granted, if you are making a lipstick composition also, you will get a patent. If you are making a phone, a telephone, you will get a patent. If you are making a machinery, you will get a patent. If you are making a new shoe design, you will get a design. Once you get it, you have to exploit it. That's up to you. We are only bothered if you are paying renewal fee. If you pay the fee, your patent is live or your design is live. The moment you don't pay, we will just inform you, and later on, if somebody infringes it, you will be in trouble. There is no exclusive club or something. There is nothing like that. The benefit you get it is that if somebody infringes, you will be in safer hands. You can go to court and validly state that you have a patent and somebody is misusing, and without your permission, they are using your patents. So backdated onwards, you will be given royalty and their what do you say? Whatever money they made, everything will be given to you, and you can have temporary injunctions and all that done. I think I had one slide of that for infringement. I don't remember if I had that. I did not have that slide. Yes, still anything else? Uh, does Startup India help in patent rights? Startup India? No, Startup India doesn't have patent rights. Startup India is for startups. They may just provide the aid, but it's not for patent rights. It's for MSMEs, no? Is to register. And the government of India is also helping MSME because if you see the patent rights, you have a special category for MSME. This is the SME. You have to show that it's a startup. Using this startup certificate, you can get the price. So patent India, Indian Patent Office is giving you reduction in fees. Normally, if you are a company, you will be paying 4,000 rupees, but you are paying only 2,000. So it's not only in the renewal fee, in the whole fee structure, you get a reduction because you are SME. That is to actually encourage the startups. Yes.